I was laid off due to COVID in April. My employer appealed and nowadays says I owe $7,000. Hi, our legal advice. I live in North Carolina. Was laid off by my employer on April 14th due to lack of work related to COVID-19. My supervisor called me and said effective immediately, I would be laid off, but that they would pay me through May 31st. I understood. Asked for a letter in writing detailing my layoff and payment, and turned in all my equipment that day. I was provided a letter by HR on April 20th saying my layoff was directly caused by COVID, and my position would be terminated on May 31st. On April 21st, I filed my claim with the Department of Employment Security. The form specifically asked the last day worked, which I understood to be April 14th. Since after that date, I no longer performed any duties for my employer, nor did I have the equipment to do so. I understood the payment to be a form of severance or separation pay covering the period from the 4/14 to 5/31. Per the day website, it says that claimants should not delay in filing even if receiving separation pay. In my claim, it asked whether I was receiving separation pay or severance, which I answered yes to, as well as uploading the letter from my employer under the section asking for the reason for the layoff as well as the section for proof of separation pay. My claim was approved and I started receiving benefits from the week of April 19th. On each weekly certification, it asks whether the claimant is receiving separation pay or severance, which I answered affirmatively on all weeks from 4/19 to 5/31. Due to the federal unemployment program, I received an additional $600 per week during these weeks. Right before the deadline for appeals on my claim, my former employer filed an appeal stating that I was not laid off until May 31st. A hearing was held on October 12th between myself, the employer, and the appeals referee, where the employer did testify that the period after 4/14 was severance but I was still on payroll until May 31st. In my testimony, I did not deny this, as that is how I filed the claim and provided the information for it in my initial claim and submitted the letter from the employer outlining it as well. The appeals referee, however, turned on me and asked me why I did not disclose that I was receiving payment and the amount received in my weekly certifications. I testified that I had filled out the form completely, answering in each week that I had said yes to the question about separation pay, but was never asked for the amount I was paid. I have copies of all my weekly submissions as well as proof that there is no place to input the amount. The referee affirmed that I was wrong and had not provided enough information. Day has come back with their appeal decision saying that I was not eligible for benefits from 4/19, 5/31, and now I owe that money back, totaling nearly $7,000. I am not disagreeing that I was receiving payment from my employer during the time that likely would have disqualified me from being eligible during that time, but I also filled out all forms completely and truthfully. I am just trying to figure out if there is any defense or help that a lawyer might be able to provide, since it seems like I am getting punished for following the exact directions and process set forth by Day, but they were not thorough enough in reading the provided evidence on the claim and following up with asking the amount I was receiving as separation pay. Edit. Thanks for all the responses. I should note, I'm not saying that I felt like I deserved the benefits for those 6 weeks. I'm just wondering if there is anything in the process to protect me from what I feel like is in error on the Day side. Punishment is probably the wrong word. More that I feel like this could have been avoided from the get-go. Whether that be on my end from knowing how the state defines unemployed, or Day from handling the information for the claim. Honestly, I wouldn't be as worried if I wasn't still unemployed, but even with an engineering degree, I haven't been able to get a new job since. Thanks to you, Ballard, people know me for pointing out that I can apply for a waiver for non-fraudulent Overpayments. Severance pay is a lump sum or monthly paid sum after your employment ends. You are still on payroll but not asked to work. Your letter from your employer says your last day was May 31 and that is what matters. You were on payroll and still employed even though you did not have to show up and work. The letter said your position would be terminated on May 31st, so you were employed until then. You have to return the money. There is no way around this. You said you were unemployed and you were not. Does not matter that the certification did not have a place to put the amount paid. You are wrong in the basic premise. No lawyer is going to find a loophole for you as you were employed until May 31st according to the letter and you pay back the money. But my understanding is that at the end of the day, it won't matter who made the mistake. If you weren't entitled to the money, you have to pay it back. Kind of like if the bank accidentally put $7,000 into your account. It was their mistake, but it doesn't make the money yours. You refer to it as being punished, but it's not a punishment to not get to keep money that was never yours in the first place. It would be a punishment if they rescinded money that you had been actually entitled to. Is it fraud? No. Fraud implies that it was done knowingly. Is it an overpayment that they will collect from you in some way, shape, or form? Yes. Appeal it. Try to get some of it waived. You can probably get a judge to rule you owe less, or set you up with an incredibly lenient pay arrangement. Unfortunately, this is an administrative error due to a misunderstanding. But you aren't entitled to that money. It's not a punishment, but rather a case of the government going, "We're too stressed to check stuff, we're going to take what you said at face value, and if it's the wrong amount we'll make it square later." This is them making it square. I agree with other commenters about you still being employed until May 31st. But wanted to answer your question directly. I also filled out all forms completely and truthfully. I am just trying to figure out if there is any defense. Likely not. The UI office can correct mistakes. And even if you could successfully argue that you received post-separation pay, the link you provided states these payments may affect an individual's unemployment insurance. This happened to me, in a different state, right around the same time as you. I was laid off immediately, but given a severance. My state disqualifies you from UI until your severance payout ends. Even if you receive a lump sum, they calculate the effective time window you were paid for. In their haste, I was originally approved back to my termination date. After collecting benefits for 7 weeks, I was contacted and notified of the mistake. I should have been ineligible for the first few weeks. They suspended benefits until my received benefits caught up to what I was eligible for, at which point they resumed paying out. Ask Day to set you up on a repayment plan and waive any fees. They are typically willing to do so as you are making an attempt to repay the money that wasn't rightfully yours. As stated over and over here in the comments, you filed incorrectly as you were still employed through the end of May. As the letter from your employer stated, you were still on payroll and still getting paid. Bottom line, the unemployment and CARES extension were not rightfully yours to claim until you were no longer receiving a paycheck. Please review the CARES Act, specifically for the Pandemic Unemployment Assistance and the Federal Pandemic Unemployment Compensation, the $600 per week FPUC. There is specific language regarding waiving overpayment of FPUC due to compassionate circumstances. You'll have to request waiver, and appeal the decision. Your hearing is likely not the end of the line for appeals. Now, as an employee of this agency, my question would have been to you: why did you file your claim before you were unemployed? I'm not quite sure I understand what happened. But if your severance was paid in one lump sum, you would declare that in the 1 week you received it. If it was paid out weekly, The amount you were paid should have been reporting this payment during that week, which likely would have made you ineligible for benefits until the payments ended. In any case, it doesn't sound like Day made the mistake. It sounds on the surface like you reported incorrectly, that you took advantage of the situation to get enriched by the FPUC payments. Or you can, and should appeal and request a waiver of overpayment. And, should you lose that, make payment arrangements. As long as you keep your end of the agreement, the collections won't get nasty. Good luck! This isn't the end of the world, in the larger scheme of things. It's just another bill. Aside from the advice already given top, I'd recommend calling Day and asking to speak with their collections team. If you haven't been contacted already, they can adjust future benefit weeks to assist in repayment, and may be able to defer payments if you're off unemployment but trying to stabilize your finances. They understand the situation, and I guarantee you that's not the biggest bill they'll see today. They'll have plans to help correct the overpayment. This sounds like your last day was 5/31, so you wouldn't be eligible for UI until 6/1. But you didn't fill it out truthfully. Just because you weren't required to show up to work doesn't mean that was your last day. Your last day is when you remove from payroll and no longer receiving weekly, bi-weekly employment checks. Your letter also reflects this. Severance is handled completely different and isn't paid out in the way you have described. You can claim ignorance, but you will still be liable for the money, and getting a lawyer will not change this fact. If you need to, try to arrange paying it back in incremental payments. You provided false information. You were laid off due to lack of work, but you are still on the payroll, which means that you were employed until May 31st. That's the date you should have put down as your employment end date. I'm not saying that you did this dishonestly. Sounds like an honest mistake on your part, but you still have to pay back the money because you weren't entitled to it. You were still being paid your salary, which is not what severance pay is. I am just trying to figure out if there is any defense or help that a lawyer might be able to provide, since it seems like I am getting punished for following the exact directions and process set forth by Day, but they were not thorough enough in reading the provided evidence on the claim and following up with asking the amount I was receiving as separation pay. Ideally, you should have had a lawyer with you during the initial Day hearing. Talking to a lawyer before the hearing would have also helped you understand the actual laws and what you could realistically expect from the hearing. It's unlikely you will get the ruling reversed with the information you provided, though, as you didn't give us every single detail. There is always a chance that some specific detail or situation you left out would change the game. But overall, the odds of that being the case here are pretty low. I only say it because I was in a very similar situation to you. I posted on here with what I thought was all the relevant information and was told I wouldn't win the appeal. Later on, I talked with a lawyer who looked at parts of the situation that I considered irrelevant. Those details helped win the appeal. That, along with not screwing up during the testimony, is why you want a lawyer for these things. My advice would be to have a lawyer review everything from up until now. Most likely they will agree that you didn't have a right to benefits and tell you to ask for something like partial forgiveness or a very lax payment plan. They have done these cases daily for a very long time and will be able to coach you on how to ask for it. Between those layoffs, you did receive payments from your employer, right? If so, you're not eligible for unemployment. A person is only eligible for unemployment benefit if they're out of work and not receiving any payments from the job and ready for work. Those questions are asked, and you must answer no for those sections to avoid any problems. In your case, they can say you committed a fraud. To avoid any further complications, you should pay back the money.
If you enjoyed this video, Please check out our playlists full of similar content. Epic Ericast is like doom scrolling for your ears. Please like, share, and subscribe.